So my name is Chaz Tyler. I'm a fellow at the Constitutional Law Center here at Stanford, and we're doing the next panel on fixing federalism and local government. We've got three very esteemed panelists here, Randy Barnett, who's to the far left at Georgetown Law Center, and Michael Greve, who we've all already met at the Scalia Law School, and Michael Toth, who's special counsel at the Texas Attorney General's office. And I'll just remind the panelists that I have these really obnoxious signs that'll indicate when you're out of time. So, Randy?
Thanks, and thanks for inviting me here. Thanks, Mike, for having me. I got involved in the issue of constitutional amendments in the spring of 2009 when various state legislators started advocating the passage of state sovereignty resolutions in their state legislatures, and reporters called me to ask me for my opinion about these. And I said, these are entirely symbolic, non-legally effective show votes. If state legislators actually wanted to do something that they have a constitutional power to do, they could call for an amendments convention under Article 5, where the Constitution specifically empowers state legislators to do something like this, and that would actually get Washington's attention, not these sorts of things. And in the wake of being repeatedly asked about these things, I decided to think about what an amendment that these state legislators might be interested in actually advocating at such a convention. And I came up with something called the Federalism Amendment, which was published in the Wall Street Journal as an op-ed in April of 2009. That got a huge response, much bigger than any other op-ed I'd ever done for the Wall Street Journal or anywhere else. As a result of that, I went to work on a larger exposition of this, and I put together what was called a Bill of Federalism, which was 10 constitutional amendments that ended up being published in May of 2009 on Forbes.com. I discovered in the course of doing that, and these were not all my ideas, they were a compilation of ideas that I came across and tried to draft into some coherent whole. I discovered that it's extremely hard to draft constitutional language. I think the people who participated in this conference, to the extent you drafted something originally, probably shared this feeling I had that it's really hard to draft something that's actually going to have the effect you want it to have and is not going to have an effect you don't want it to have. So I produced this Bill of Federalism. It contained 10 provisions, one of which, or actually two of which, are in the packet that you have as my proposals, one of which came to be known as the Repeal Amendment, which is one of the proposals that's in front of you today, that got picked up by some activists and started pushing very hard across the country for this amendment. And ultimately, it was introduced into Congress in the 114th Congress by Senator Mike Enzi and Congressman Rob Bishop, and they smuggled me into the Senate gallery to see the press conference that was held with a group of senators and congressmen proposing this. Facebook told me about an hour ago, I just happened to check Facebook, that today is the 6th anniversary of the date that was introduced into Congress, May 12th, 2011. The Repeal Amendment, which allows two-thirds of the states to call for, to repeal any federal law or regulation, the legislatures of those states. At any rate, rather than talk any more about this, I thought to break up the afternoon, I would show you a short video of me defending the Repeal Amendment on CNN. Then I'll come back. I have a couple comments to make. To elaborate on from this presentation, but I thought this would amuse you.
We need a repeal amendment. Just explain that to us.
Well, originally, in the original Constitution, states did have a formal role in checking federal power. It's when they selected senators. Senators were selected by state legislators, and with the enactment of the 17th Amendment, it ended that formal role, and as a result, federal power has no formal constraint on it. You have to rely entirely on the courts, and they haven't really done a very good job in doing that.
But as I understand it, the way your repeal amendment would work is that if two-thirds of states don't want a certain federal statute, then they can repeal it,
right,
according to the amendment.
If two-thirds of the states decide to repeal a particular law or regulation, then it will be repealed. But if Congress really wants that law, they can reenact it.
They can by a simple majority.
Right.
So if you can just, wouldn't we just be going back and forth all the time?
It actually amounts to a second look. It would require Congress to take a second look. Congress passes a lot of things as part of omnibus bills that they don't really pay close attention to, or sometimes maybe they just get off the rails politically. It doesn't happen very often, but it could happen. And in this case, if Congress really thinks they're right and the states are wrong, they can reenact it.
Randy, really what's going on here is that you have drafted what you call a states' rights Bill of Rights.
That's Elliot Spitzer, in case you don't recognize him.
The critical provisions of which would let states repeal congressional enactments, eliminate the income tax, and basically it would be a return to the Articles of Confederation, which was dysfunctional government. Now, there's no question it could be done. There's a constitutional mechanism for doing this, but wouldn't this just turn us into a dysfunctional set of 50 states without any coherent government? And if anything, today we need the capacity to act more quickly and with greater certainty in the world we live in.
Well, I'm not in favor of returning to the Articles of Confederation. The Bill of Federalism that you reference actually dealt with a lot of individual rights, not just states' rights. But in fact, what we did when we passed the 14th Amendment was we put a federal check on state power, which was essential. In fact, I wouldn't be in favor of the Constitution if it didn't have a 14th Amendment, but what we really lack is a reciprocal state check on federal power, so it basically just equalizes the playing field.
No, we do have that check. It is the fact that we elect members to the House of Representatives and the Senate, but I want to come back to the two key provisions here. States can get together and override a congressional enactment, and you want to take away the power of the federal government to tax, which, as we all know, for better or for worse, is the income tax, which is the critical provision. And you take those away, the capacity of the federal government to lead us in a coherent way disappears.
Well, that proposal, which was one of 10 proposals I put together on Forbes.com, is not on the table today. But what that proposal did allow for was a national sales tax. So it wasn't no tax at all. It was no income tax.
But let's come back just to the repeal.
Nobody's debating that today.
Okay, but let's come back just to the repeal amendment, because what I have heard from the more conservative side of the political aisle recently is that what business needs is certainty. What business needs is to understand what the laws are and what the tax rates will be, what the regulations will be. If you create this enormous question mark where states, after a bill has been passed, signed into law by the president, the states can then get together and at any time in the future repeal it, doesn't that, from your own political perspective, create the most massive uncertainty possible?
Well,
so wouldn't that be devastating?
I'm not pro-business. That's not my thing. I'm pro-liberty. And the way we get liberty in this country, the way we've had liberty in this country, is by checks and balances. So I think I'd ask anybody who's considering this proposal just to ask themselves a question. Does this make the Constitution a better Constitution, or does it not make it a better Constitution?
Is this really a way, though, to repeal the health care bill? Isn't this really a vehicle for that? And why would you do that anyway, since we have 20 states arguing this, challenging unconstitutional?
It could be used for that, but I think really what a lot of people amongst the general public now are very concerned about sort of runaway federal power. It actually started at the end of the Bush administration, and it continued in the beginning of the Obama administration. It's really made a lot of people upset. And I think rather than pass thou shalt not provisions in the Constitution that then have to rely on the courts to enforce, an internal structural checks and balance is the way we've done things in this country. And I don't see any reason why you can't trust the legislatures of 2/3 of the states to exercise their judgment as elected representatives of the people.
Elliot, then I have a question.
The premise, and I've read your articles, and as I said, there's no question mechanically you could do it if the public wanted to do it. You can amend the Constitution to create the structure. But the premise of your argument is that somehow state government has been more rational and more seasoned and reasonable over the last 50 years than the federal government.
I don't necessarily believe that, Elliot.
Well, but that is why you're giving this huge additional power to state legislatures.
I'm skeptical of government, whether it's state government or federal government. We have federal control of state governments under the 14th Amendment and other provisions. That already exists. I'm all for it. What we don't have is any constraint on federal government. So where are you going to reside the constraint if the courts won't do it?
Let's bring this down to a specific situation. Let's take perhaps the civil rights laws in the mid-1960s. Would you have wanted state legislatures, and that was an incredibly difficult political moment, and I hope you would agree those were good laws that have moved the freedom forward.
Absolutely.
Would you have wanted states, and it was intensely unpopular, to be able to override that and take it back?
It was only unpopular amongst a very small number of states, never anything close to amounting to 2/3 of the states.
I disagree with you.
It had overwhelming bipartisan support by both Republicans and Democrats. It was only the Southern Democrats that didn't like that idea.
But bills like that would then be subject to the second look, where when we have done things that were transformative, that often were, and I disagree about the politics of the moment in the 60s, put that aside, when we have done the things that were transformative, the politics of the states were very, very difficult. Every one of them, from the New Deal to the Civil Rights Act, to, in fact, President Reagan's tax rollbacks, which you probably supported, and I don't question that right now, those all would have been subject to a second look, so the capacity of the government to be governed, for the country to be governed, would have been challenged.
A second look when 34 state legislatures that are bicameral, so you're talking about 68 state legislatures between the Senate, the upper house, and lower house, get together, and it's going to be a red state, blue state. You can't get to 2/3 of the states without having it be red state and blue states. But there are things that the federal government does that interfere with the internal operations of the states. Those aren't particularly popular. There's things that may be done accidentally, inadvertently, as part of big bills, and states would have an opportunity, for example, fight back against unfunded mandates. That's not the kind of thing that the general public is all that riled up about, but state legislators are concerned about.
So that was Elliot Spitzer. I hope you recognized him. Before he was on CNN, he was a Harvard Law student, and on the Harvard Law Review, he's a very smart guy. Anyway, so after this happened, since this has happened, there has been a development of a movement called the Convention of the States, calling for an Article 5 convention. That would be for purposes of proposing amendments on 3 topics. The topics are limiting federal power, limiting the terms of federal offices, and imposing or enacting some kind of fiscal constraints on the federal government. That movement has now resulted in 11 states calling for such a convention. Last week, Texas state legislature called for such a convention. And last fall in Williamsburg, Virginia, there was a simulated Article 5 convention that was held by the Convention of the States, in which representatives of 50 states convened in Williamsburg to deliberate on amendments. These were primarily made up of state legislators from around the country. And what I decided to pick for this conference were 2 of the provisions that they adopted. They were 8 proposed by subcommittees. I was an advisor to one of the subcommittees on federalism. The body approved 6 of the 8 proposals, and 2 of them I picked as my amendments here. This is the legislature. This was a limitation on on federal government. Okay, that was. Okay, this is. The repeal, this is the regulation of commerce. So this is a Federalism Amendment that limits Congress to the original meaning of the commerce power and eliminates a number of judicial decisions to the contrary. This was one of them that was adopted. This actually was also in the Bill of Federalism in Forbes.com. The other one is their version of the Repeal Amendment, which was much longer than the one that was introduced into Congress. They called it an abrogation amendment. The only general point I want to make before I end here is to elaborate on what I said there, and it really echoes what Sandy Levinson said. I do think that you have to ask yourself the basic question, does any proposed amendment make the Constitution a better Constitution? Not whether it enshrines into the Constitution a policy judgment that you like or don't like. I don't think that's the best use of the Constitution. It does tend to create parchment barriers. And to make the Constitution a better Constitution is to make it structurally better, as opposed to another rights provision, shall we say. And so the 2 provisions I have are intended to be structural. The first is the Repeal Amendment, which creates a structural check that's self-enforcing. It's something that state legislatures do and not courts. And the second is much more substantive because it talks about the Commerce Clause, the reading of the Commerce Clause. But in the spirit of the 11th Amendment, which reverses Supreme Court opinions, it's attempting to limit the federal government to particular exercises of powers, which would then leave all of those powers in the hands of state governments. So it doesn't prevent government from regulating, but it's a structural provision to say that these regulations should be done at the state level rather than the federal level. So my basic plea here is to consider that structural amendments will work better than substantive amendments, and they would help address the question that I think we all should be addressing when thinking about an amendments convention that might propose amendments, although I have to say this conference may be giving me second thoughts about the wisdom of such a convention. Is whether it will actually make the Constitution a better Constitution.
Thanks. Rick Pildes.
Well, after watching the CNN exchange there, I'm not sure if there's still a role for me as a commentator.
Not sure what you could add to Elliot Spitzer.
I did actually record a video on my phone, though, of my reaction to your proposal, so I thought, but anyway, I want to be sure to thank Michael, and whenever I'm out here, I sort of have it at the back of my mind that I should thank Leland Stanford for having the wisdom and the money to fund an institution in this glorious environment. Every time I'm here, it's all I can think about is how glorious it is to be here. I'm going to start by accepting, for the sake of these comments, the political judgment and the premises that underlie Randy's proposals, that the federal government is too large, it's overreached. I don't think it'd be interesting to kind of push back against the premises here in this context. So assuming that's the case, how good a job would these proposals or the particular repeal proposal do in reaching Randy's objectives? And I want to start off by saying I do think that the more interesting and more significant proposal is the repeal proposal, precisely because, as Randy said, it's a structural, institutional, political kind of check on national power. It's meant to be a replacement for, to some extent, separation of powers, the checks and balances as originally envisioned, but also for the ending of the senators being chosen directly by the state legislatures. And so it reminds me of the override provisions that some constitutions have for judicial decisions of courts, as in the Canadian Constitution, for example, where a majority of the federal legislature or a majority of any individual provincial legislature can override a judicial decision of the constitutional court. And a number of other countries have, not that many, but some have these override kinds of provisions, a political veto, if you will, of a judicial decision interpreting the Charter on Rights and Freedom in the Canadian context. Okay, a couple of questions or concerns I do have about the proposal. One is actually a question of how, whether it will even work significantly to do what you want to do. And the reason I have a concern about that, or a question, is that in today's world, what we have is the nationalization of all of our elections. So right now, with the polarization of the last 20, 30 years, voting for members of state legislatures and for governors is highly, highly correlated with national politics, like the popularity level of the president who's in power and his party. And so there's so much less of an independent sphere of state electoral politics. I mean, we think it's there. We have our races, we pay attention to them. But in terms of actual patterns of voting, the elections have become so nationalized that the separation between the state and the federal electoral realms is not as distinct as it once was. So if you have national legislation that's going to have to be supported by the president, or in a rare case, overcome a presidential veto, how likely is it that even 2/3 of the state legislatures, or 60%, would, in your current proposal, 60%, would actually provide this checking function? So that's one question I have. Second, I would certainly want to exempt anything having to do with international affairs from this kind of power, for a couple of reasons. For one, the assumption of the state check here is that these are areas that states ought to be regulating rather than the national government. That's why the states are given this veto power. The states are constitutionally disempowered from acting in lots of spheres of international relations. They can't make treaties and the like. And so there are deep structural reasons the framers actually did want to take the state legislatures out of that role. They understood that there'd be a much more parochial mindset that would prevail there. That's why the Senate, not the House, is involved in treaties. That's why there's admiralty jurisdiction for international affairs, prize cases, et cetera. That's why treaties are made the law of the land. So I would be deeply concerned that all those parochial forces are not ones you want to bring to bear in overriding national judgments on international matters. The third thing, you actually alluded to this, and it made me a little bit more comfortable. In your current proposal, the one you gave us, it's a 60% override. And I'm not sure that's high enough to avoid this just becoming another vehicle for the straightforward partisan political conflicts that we've already fought over for one round in Congress. And it's currently the case that 60% of the state legislatures are controlled by one party in the United States. So 60%, which is in this proposal, isn't enough to ensure that you get that bipartisan support. I was glad to hear you say you want this to require bipartisanship in the states. So you might have to raise it a bit. 2/3 maybe is good enough. Maybe you put the governors in there. You left them out of this proposal. But I just want to make sure that if we were to go down this path, the threshold would be high enough that it would ensure there'd have to be bipartisan rejection of the national policy across the states. So, but I like the fact that it's structural, it's institutional. I don't think the paper parchment in the other proposal is likely to do much effective work for reasons you already alluded to and Sandy mentioned earlier. Thank you.
Thank you.
I should just mention that my proposal that was introduced in Congress had 2/3, and it was the state reps in the Article 5 convention that picked 60%. That's where that came from.
Michael?
Thank you very much, and thanks, Michael, for the kind invitation. Let me say a few words sort of preliminarily about how I thought about this. I interpreted this invitation as one to think about really big fixes, and I think those kind of big fixes should satisfy certain minimum conditions, largely consistent with sort of previous exchanges here. I think first that whatever is being proposed should be structurally compatible with the Constitution as it exists. So I think one ought to treat for those purposes the existing structures that Sandy calls hardwired, the Senate and bicameralism and judicial review and federalism as a given. I think one should stick with decision rules and not distribution rules. And I think, and this is an important point, whatever is being proposed should be politically neutral in the sense of leaving a lot open to ordinary future politics, and that includes sort of brutal battles over the size and scope of government. I think second, sort of big think proposals should have a certain long-term veil of ignorance quality. You choose this rule regardless of your expected position in society now or going forward. And you ought to believe with good reason that the rule will hold up under the various crises of human affairs and over the long haul. And finally, any proposed amendment, to my mind, should fix a problem that can't be fixed through ordinary politics. The two proposals I came up with, or borrowed, I should say, satisfy these conditions, I think, for reasons that I'll mention. I've borrowed them from very different sources. My friend Jim Buckley, Senator Buckley, who proposed this, the underlying policy as something Congress should do. I've been trying to persuade him that, no, you have to do this by constitutional amendment. And the other one is an old proposal by Jim Buchanan, and I should alert you in advance, Sai Prakash has a proposal along those lines. It would work somewhat differently, but the budget proposal already has twice as much support in this audience as anything else. The amendments actually sort of go together. Obviously, other than both authors are Jim's, they deal with fiscal matters and with the practice of routine peacetime debt finance, the increased fiscal imbalance between the feds and the states and all the attendant consequences and so forth. Less obviously, I think they respond to the same set or a common set of problems stemming from very similar sources. In 1960, neither of these amendments would have made the slightest bit of sense. From the founding to that time, 1960 around, American fiscal and budget policy rested on a very firm consensus. We run up debt in wartime and pay it back in peacetime. There are a few wrinkles on that consensus, but the idea of debt financing peacetime consumption had never occurred to anybody at all. And likewise, federal transfers at the time to states were very, very limited, much under 5% of the federal budget, and most of that was dedicated to infrastructure, the highway program that was then running out, not to consumption. Fast forward 5 years to 1965, it's a totally different world. The Great Society programs embody a commitment to debt finance and to massive consumption-based transfer programs, Medicaid, education, and so forth. A decade later, by 1974, 1975, those programs had begun to bite and showed up in the federal budget in the form of deficits. And a decade later, they had become effectively irreversible. 3 decades later, they're still irreversible, except more so. I'll explain that. Now, at the time, there were clever economists who explained all of this, Walter Heller and all of these people. So a lot of neo-Keynesians argued that it's good to run deficits, and there's no harm in any event to smooth out budget cycles. Well, it turns out the budget cycles come and go, and debt finance lives through boom and bust. There were lots of fiscal federalism theorists who defended transfers as a way of implementing counter-cyclical policy and equalizing locational advantages among states, and as a way of harmonizing federal purposes with local control. In 5 decades since, not a single one of these federalists has found a single program that even approximates even one of those purposes in real life. What most of these theorists have found instead and consistently is that these programs, transfer programs, drive fiscal excess at all levels of government, produce moral hazard and bailout expectations, create impenetrable intergovernmental bureaucracies, and most of the money that's spent on these programs ends up not with the supposed beneficiaries, but with the apparatus that administers them. So the models work until politics intrudes, and unfortunately has a tendency to do that. So with the result now is that the national debt now approaches something like $100 trillion. Federal funding programs in many states account for 1/3 of all state spending, and we're one economic crisis away from actual state insolvencies. If you think that's not a problem, the national debt is not a problem because, says Steve Moore, we're going to grow out of it, or because President Trump says doesn't matter because we'll pay back the Chinese in pesos or the equivalent, fine, be my guest. And if you think that state-level insolvencies are not a problem because we can always treat Illinois like Puerto Rico, fine, be my guest. But if you are worried somewhat about these things, I think you'll share my further worry that there's nothing much that we can do about it by ordinary means, and that's for 2 reasons. One, for all the talk about polarization in America, I think these twin commitments to debt finance and fiscal transfers rest on an overwhelming consensus among the American electorate, for which you could find 95% consensus, and it goes like this. First, let's be a modern country and have a really big welfare state. Second, let's not pay for it. This is called the deficit and the national debt. It's the entitlement programs that drive, that now crowd out defense and all other kinds of spending. And third, let's lie to ourselves about all of this. Social scientists have sort of documented, it's actually an impressive array of things, so many ways in which we sort of disguise the size of our transfer state. By some measures, it's larger than France's. We're just better at disguising it and structuring transfer programs as programs for state and local governments is one of the ways of doing it. And the second thing is, even if you could challenge this consensus in some way, there's no way the political system could credibly recommit or commit to the constitutional fiscal federalism arrangements that we had up until roughly 1960s. Fiscal credibility really is like virginity, right? That is why it's a fitting subject for a constitution, because constitutions are commitment devices. And so what these proposed amendments are is recommitment devices necessitated by sort of the demise of presuppositions, unstated proper presuppositions on which the Constitution rested for a good long time and then ceased to rest. I emphasize that these amendments do not enshrine any particular policy any more than the original Constitution does. This is not a municipal code for Dagny-Taggart's Valley. The Buchanan Amendment is consistent with any level of government spending, provided it's paid for. The Buckley Amendment is consistent with any level of transfer payments, provided the payments are made to people and not to politicians. I'm not wedded to any of these details, so you could tie the Buchanan tax to a gas tax or a VAT. Jim Buchanan himself wanted the tax to be raised in the most oppressive and inefficient form possible, so as to teach people a real lesson. I've tied it to the income tax because that can't go away, right? And right, because the deficit tax, if that's what you want to call this, is just sort of then reflects sort of a collective judgment about distributive consequences of the tax code that we've already made. But I'm totally open to other suggestions. Similarly, I mean, Jim Buckley would permit zero fiscal transfers. I've put in these 3% so that there can't be any yammering that Stanford could still get federal grants and Berkeley couldn't. I'm fully aware that the 3% will sort of be a floor, not a ceiling, or floor as well as a ceiling. I'm willing to pay that. Maybe I'm wrong about that. Yeah, I'm totally confident, and this is my last sentence of this. In a constitutional moment of reflection and choice, no sentient human being would choose our current arrangements of unrestrained debt finance and uninhibited fiscal transfers and institutionally entrenched self-deception. I'm trying to persuade myself that in a moment of reflection and choice, people would actually embrace something like this. Thank you.
Thanks, Michael. And Jamal Green from Columbia Law School.
Thanks. That puts a lot of pressure on me, I think. So there are, as Michael says, there are two pieces to this, and they're really connected to each other, and not just that they're both about fiscal policy, but that I'll call it the Balanced Budget Amendment. You didn't call it that, but I'll call it that. The Balanced Budget Amendment, it becomes effectively nationwide if you also have the Federalism Transfer Amendment. So I'll just say something, I guess I'll spend my 5 minutes really just talking about the degree to which I think, without getting too far into the politics, the degree to which I think these amendments satisfy Michael's conditions, those conditions being politically neutral, they don't, so structurally compatible with the existing hardwired Constitution, consistent with the original position, and something that you can't fix through ordinary politics. So first, I'm a little bit skeptical that these proposals are politically neutral, in the sense that the decision whether to enact federal programs, administer them federally or administer them through state and local governments, strikes me as a substantive one that reflects a view about the relative pathologies of local versus federal administrators. The decision to eliminate peacetime deficit spending, I think, reflects a substantive preference for fiscal austerity, and I'm going to say more about that in a moment. And this two-thirds majority requirement, which is a kind of a fail-safe, is not an ordinary political process, obviously. It's a process that would be sufficient to amend the majority of the world's constitutions, although not our own. Second, and maybe more importantly, I'm not sure the basis for saying that one would prefer these amendments from the original position, or behind a veil of ignorance. I wouldn't expect someone in the original position to have any particular view about fiscal federalism, although I'm happy to be proven wrong about that. But more importantly, I think that such a person might well have a view about the level of, or relative levels of poverty and economic malaise that we would consider tolerable. And I think these amendments would bear upon those levels. Michael notes that these amendments would not have been needed in 1960 because of a consensus about American fiscal policy. But of course, in 1960, the poverty rate was 22%. Today, it's about 13%. 1960, the poverty rate among African Americans was over 50%. Today, it's about half of that, about 25%. In that time, of course, federal spending on anti-poverty programs has ballooned from about 25 million to well over 500 million, 25 billion to well over 500 billion a year. And that doesn't include Medicare and Social Security, which are designed to prevent rather than ameliorate poverty. And so Michael can say, well, we can still achieve those aims, we just have to pay for them. But to my mind, ordinary human psychology is also part of the original position. And indeed, that's why we have constitutions in the first place. As Michael points out, and this is maybe just amounts to a political disagreement, as Michael points out, deficit spending dramatically lowers the political cost of redistributive welfare policy. And to expect wealthy and middle-class Americans to pay in a transparent way to take people out of poverty, especially when a disproportionate share of those people are racial minorities, is, I think, to fantasize. I think that's just not going to happen as a matter of politics. And this is all quite apart from the predicted effects that a balanced budget amendment would have on the length and severity of economic recessions. Michael disagrees with a lot of economists, and so one would have to sort of work that out in some way. But just to name one example, so imagine if the FDIC insurance during an economic collapse were subject to a supermajority vote in Congress. Imagine what that would do to financial markets right now. So in the end, it's really not that I'm defending deficit spending as such. It's that combating poverty also involves a psychological commitment device, in this case, heavily leveraged spending. And I'm not sure how to weigh that kind of commitment against a pre-commitment to fiscal discipline without relying on some substantive view about poverty or about human welfare. So as noted, again, these amendments are connected to each other since state balanced budget requirements are part of why federal transfer programs are required. One final point, and this Michael mentions this at the end, you might say fiscal discipline is not politically available anymore, if it ever was. And so in some sense, the deck is stacked in the other direction. That's part of what this is responding to. But I would just note that, and just in service of the view that this can be ordinary politics, that's my last sentence, the current Speaker of the House has proposed privatizing Medicare. The last Republican president proposed privatizing Social Security. I think that I'm just not persuaded that the politics are such that this is just sort of impossible to enact through the ordinary political process.
Thanks, Jamal. And Michael Toth.
Thank you very much. Although I work for the Texas Attorney General's office, the views here are my own. And I can safely say my own views, I'm very grateful to be here. And I thank Michael McConnell and the Constitutional Law Center for inviting me. Of course, up until the present moment, states in general and state attorney generals in particular have had quite a lot to do with the relationship between the states and the federal government. And for that reason, I was initially drawn to the panel on federalism. So by way of background, the first place that I looked was the 10th Amendment. And even to this day, the textual anchor in suits brought by states against the federal government for overreach is the 10th Amendment. The 10th Amendment provides that powers not delegated nor prohibited to the states are reserved to the states and the people. So initially, I thought, and I'll leave this for further contemplation, is perhaps a reframed 10th Amendment would have a non-exhaustive list of the powers which are not delegated to the United States and belong, therefore, to the states and to the people. Of course, we could say that's unnecessary, but as was stated earlier, redundancy can be a good thing. But of course, I digress on the 10th Amendment because the real action in litigation between the states and the federal government is administrative law. It is what now Justice Gorsuch called the elephant in the corner, the definition of executive power and the proper role of federal agencies. To cite from recent experience here, the current Attorney General of Texas, Ken Paxton, my boss, has filed 27 suits against the federal government. He's been Attorney General for about 27 months, so it's about one lawsuit per month. And I went and I looked back at most of these 27 cases, and while arguments under the 10th Amendment were raised and sometimes briefed, really in the decision, the driving factor was the proper role and the proper authority and the scope of the authority of federal administrative agencies. They are all, in one way, shape, or form, administrative law cases. And I think it's important to note here also that current federalism jurisprudence and 10th Amendment jurisprudence in the U.S. Supreme Court provides meaningful opportunities for states to push back against federal overreach. So just a few recent examples of this for those keeping score at home. NFIB against Sebelius, the first Obamacare case. Of course, it's well known for the U.S. Supreme Court upholding the individual mandate. But in that same case, the U.S. Supreme Court held, a majority of the court, that federalism concerns prevent Congress from offering the states the option to expand Medicaid or lose 10% of their overall budget. At 10%, the federal inducement turns into coercion, and it undermines the independent sovereignty of the states. And whatever anyone thinks, the 10% rule is just great for math challenge litigators. All you need to do is just move the decimal point one place to the left, and you know if it's certainly violative of NFIB. Also, there's the clear statement doctrine, and the clear statement doctrine was articulated most recently in an Arlington Central case. And what the clear statement doctrine holds is that the federal executive cannot add conditions to federal grant programs that are not clearly stated in the legislation. So in other words, the executive is bound by the clear statement that Congress gives when administering grant programs. And that's another limitation on federal power, which is a recent aspect of the Supreme Court's federalism jurisprudence. All this is to say that the problem lies elsewhere. The current regulatory framework, and now we shift from 10th Amendment jurisprudence to the jurisprudence of the court around the power of federal executive agencies, really turns separation of powers and federalism on its head. What we see is a combination of legislative, executive, and judicial power in the same hands. And whereas the Constitution allows federal law to defeat state law, federal administrative action overrides state law and therefore undermines federalism. The amendment that I suggest is expressive of what is already in the Constitution. Article 1 already provides a general rule that the federal government may impose rules of general applicability prospectively only through the legislature. Article 1 vests all legislative power in the legislature, thus preventing the executive from imposing legal obligation. And the Supremacy Clause allows only laws of the United States made pursuant to the Constitution to override state law, therefore preventing executive obligations or obligations driven by the executive from overriding state law. The text of the Constitution reflects an intellectual tradition that was hostile to the regulation of society outside of the legislature. In 1610, Edward Coke voided a regulatory offense that came from the king on the idea that only Parliament can create new offenses, and the king cannot add offenses which were not already defined by the Parliament. In an opinion before he was elevated to the U.S. Supreme Court, then Judge Gorsuch again noted that Enlightenment theory and hard-won experience proved to the framers a wisdom of separated powers. And under that theory, an avowedly political legislature is endowed with the ability to make generally applicable prospective laws to govern society. What has occurred, however, in recent jurisprudence around the issue of the power of federal regulatory agencies is really an encouragement of overreach on the part of these agencies. The lawmaking authority has been undermined. And what we have seen is judicial deference, even when the new rules override existing judicial statements as to what the law is. All of this has led, importantly, to an erosion of civil liberties. Administrative power has prevailed, though I would say not as much as one would think, and I think that provides some of the hope for an amendment like this. And I'll give some recent examples of why I don't think administrative power has prevailed so generally. One comes from King v. Burwell, which is the second Obamacare case. In King v. Burwell, the court did not defer to the administrative agency. It held that in major questions, or questions of deep economic and political significance, the court must simply interpret the law. And that's what the court did in that case. So there is an exception to judicial deference in these cases. That comes from King v. Burwell. Also, there has been a movement recently among lower federal court judges in the circuit and the district level to use the traditional canons of statutory interpretation in Chevron-type cases to really see if there's an ambiguity in the underlying statute or not. And what the movement in this direction has done is it's brought legal text and legal analysis, the analysis of statutory text, back to the forefront in cases involving administrative agencies, rather than these cases being decided on the grounds of deference. Thirdly, I speak here from some experience, Texas against U.S. Okay, well, which Texas against U.S.? There's a few of those. A year ago tomorrow, the Department of Justice and the Department of Education issued the Dear Colleague letter that dealt with the issue of access to restrooms in public schools. A lot's happened, of course, in the past year, so I'll just do a quick recap of that case and how it shows, again, a movement back, I think, towards statutory text. In that case, Texas, along with a number of other states, brought an action against the federal government. Department of Justice's argument was that DOJ was owed deference under the current standard, and if that deference were applied, the statements of the administration in the Dear Colleague letter could be enforced. When pushed, however, it's very interesting that the DOJ lawyers made sort of another argument. They didn't make it so fulsomely, but they did offer another argument, and that is that they really didn't need the Dear Colleague letter. They could prevail even without the Dear Colleague letter. In other words, the text of Title IX, as applied to this situation, provided a legal obligation. I'll leave the debate over the meaning of Title IX aside. All I'm suggesting is that that sentiment, that legal obligations ought only be imposed under statutory text, is the correct sentiment. And if you agree with that, I hope you would support my amendment. Thank you.
Thanks, Michael. And now we have Lance Sorensen from the Stanford Constitutional Law Center.
It's my honor and pleasure to be able to offer a few brief comments on Michael's very interesting and thought-provoking amendment. As I was reviewing it, I was reminded of the words of one of our Supreme Court justices, which he gave in a speech to the ABA. He said, "Never before have the activities of the people been so beset and bedeviled with vexatious laws, prying commissions, and governmental intermeddling of all sorts. If I were asked to name the characteristic which more than any other distinguishes our present-day political institutions, I should answer the passion for making laws. The prevailing obsession seems to be that laws, like the crops, enrich the country in proportion to their volume. Unfortunately, however, the average lawmaker does not always know what he is sowing, and the harvest which frequently results is made up of strange and unexpected plants, whose appearance is as astonishing to the legislator as it is disconcerting to his constituents." The Supreme Court justice who spoke those words was George Sutherland, and he gave that speech in 1917. That's 100 years ago. If Sutherland had not died of a heart attack in 1942, I'm certain he would have had a heart attack sometime upon learning of the explosion of regulatory lawmaking. The word law is used 55 times in the Constitution. By proposing this amendment, Michael asks us to confront three fundamental questions. First, what is the law of the United States? Second, what is and ought to be the supreme law of the United States? And third, like Professor Barnett, he asks us to consider who is authorized in our constitutional system to determine what the law shall be. Michael's amendment seeks to address this enlargement of the law through a constitutional definition of what the supreme law isn't. He does this by excluding from the Supremacy Clause law-like things, which he defines as rules, interpretations, etc. And for ease, I'm going to call these things the midrash of the law, which are law-like things that are peripheral to the central statutes. Michael suggests that the sovereign people have become too lax in defining the law and asserting authority over lawmaking, that we have too easily accepted the assertion of the executive branch and Congress that law includes a host of rules promulgated by people who are far removed from the electorate, bureaucrats who are faceless and virtually nameless, who are not elected and therefore less accountable to the sovereign people if they're accountable at all. The midrash has been adopted by, to borrow a term from Donald Trump, so-called lawmakers who are not burdened with the trouble of debating and persuading elected representatives of the people of the rightness of their rules, but who yet assert that the midrash holds the same legitimacy and authority as statutes passed by Congress. Michael seeks to unburden the states, especially state courts, from following the midrash, especially where there is contradictory state law. His amendment would also serve to reinvigorate the non-delegation doctrine by forcing Congress to formally pass as federal statute any administrative rule it deems important enough to become part of our legal canon and binding on the states. As interesting as Michael's proposed amendments are, I have a couple of concerns. One of the first things you'll notice about his amendment is that he's drafted it as a standalone amendment. Excuse me, not a standalone amendment, but a change, rather like a red line change to Articles 3 and 6. And of all the interesting proposals we have in our conference, I think his is the only one to do this. If you think that Michael, though, is the first person in history to have ever proposed amendments this way, you're wrong. James Madison had the same idea, and there was a big debate in the first Congress over how to amend the Constitution. Roger Sherman won that debate, and so the Constitution since then has been amended by standalone amendments. Whether you think that Madison or Sherman had the better of the argument, I would suggest that this mode of amending has actually obtained kind of its own constitutional status, and Michael might want to think about drafting this as a standalone amendment that we traditionally use. My second concern has to do with his amendment to Article 3. I am not convinced yet of the necessity or even the wisdom of removing from the federal judiciary the power to review the midrash. As he's noted in his remarks, the judiciary is not as on board with the executive administrative state. Our newest Supreme Court justice has in the past expressed some suspicion of the Chevron deference doctrine, and other federal appellate judges have referred to such judicial deference as judicial abdication. Having noted these concerns, though, I think Michael's amendment is a thoughtful and powerful way to restructure the relationship between the citizen and lawmaking to render the lawmakers closer and more accountable to the sovereign people.
Thank you. And we have about 15 minutes for questions, and I think you were up first.
Professor Barnett, my comments, questions relate to you, but the first one goes to Professor McConnell. How come nobody told me I could use an old CNN interview instead of preparing remarks? This is unfair. Secondly, Professor, why is it insufficient in light of your proposal for the states being able to repeal federal laws that the Senate is embodied by an equal representation rule for all states, which is supplemented by a filibuster rule, which even in light of the recent changes that have to do with appointments, Senator McConnell stated that every single Republican senator opposes changing the filibuster rule for purposes of legislation. And if that's not sufficient, why instead of making this change, do you not go back to the premise for your change, which is the election of senators by state legislators? Senator Mike Lee has talked about that. That's the founder's original vision. Or is there something about state legislatures that possibly concern you?
Well, actually, this is my response to what's very popular on the right amongst grassroots people, not the intellectual group, to repeal the 17th Amendment and restore the selection of senators by state legislatures. I heard a tremendous amount about that while I was in the amendments drafting business. But I don't care for that idea very much. I don't think it worked as well as intended originally. This is a more direct way. So the most specific response to your question is, first of all, this does allow state legislatures to actually repeal a law, which having the Senate, assuming that the Senate was somehow representative state legislatures, would not have the power to do without the House and without presentment to the President. And so the Senate just doesn't have that power. It has the power to block laws, but doesn't have the power to repeal already enacted laws. So that's, at an operational level, that's the first thing. The second thing is, and I did state this in my interview, that state legislative officials are popularly elected representatives of the people as well. And there are more of them. There are a couple thousand of them instead of 535, a few thousand of them, but they're representative of the people. They do deliberate. I was extremely impressed, by the way, with the deliberations in the simulated Article 5 convention, which primarily was done by state legislators. They really know how to deliberate. I'm not saying they always actually do that in the state legislature when they're really doing it for real, but they have a skill set, like trial lawyers have a skill set, and they're just able to deliberate. And so I think having state legislators, qua legislators, doing this assessment, particularly when, and this is the last thing I'll say because I don't want to monopolize the time by answering your question, particularly when some of these laws and regulations really do affect the operation of state governments in ways that the general population doesn't know about and really could care less about. State legislatures do have an interest in their own fiscal integrity as well as the degree to which they have to conform to federal regulations. And so they would have, in some sense, the local knowledge necessary to push back against a federal law.
Hi, Amy Wax, Penn Law School. I wanted to comment on Professor Greve's proposal and then Professor Green's very interesting comment to it. So I'm reminded of Julian Simon's apothegm that which cannot go on will not go on. And I think with deficit spending, and correct me if I'm wrong, at some point, the bill will become due. We cannot go on forever recklessly borrowing money and spending money that we don't have. There will be a reckoning. Maybe it can be avoided, but I don't see how. We both talked about considering this amendment behind the veil of ignorance. So behind the veil of ignorance, if you're rich, you think, well, I might end up poor, so I love deficit spending and I love redistribution. I'm not going to vote for the amendment. I'm going to vote for the status quo. And if you're poor, you think, well, I might be rich, but then given our psychological infirmities, I'm not going to vote for helping the poor. The solution is deficit spending, so I'm definitely going to vote for that. So essentially, we have a free lunch that everybody can get behind. But I think the people who are missing in that equation behind the veil of ignorance are our children, future generations. They are the ones who are going to be stuck with the devastating, catastrophic fallout from all of this reckless overspending. So I guess I would like, a comment on that. I don't know if Professor Greve will really disagree with me. Should our children be there behind the veil of ignorance?
That's a long and complicated answer. I'll sort of just give you bits and pieces of the answer, if that's okay. Look, eventually there will be a reckoning, yeah, but that's what I mean to forestall, right? I mean, maybe there's still a way to do this without a whole lot of, catastrophic fallout. And the intergenerational aspect you mentioned that is why I'm skeptical of Jamal's notion that, oh, maybe ordinary politics can fix this. I don't think so, precisely because we have no incentive to take into account what happens to later generations. It's all, let's have a party now. I did not mean, every time I say this with sort of veil of ignorance, people think John Rawls, and I didn't mean it in that technical sense at all. It just has entered sort of the mainstream discourse, right? What I had in mind is sort of what the founders called and what Bruce Ackerman calls a constitutional moment, a moment of reflection and choice, where sort of you put aside sort of immediate concerns, right, and have a somewhat more long-term and serious perspective. You say to yourself, gee, there's really an awful lot at stake, not just for me, not just for my kids to the extent that I give a rip about them, but for the country, right? And I would look to, not sort of Rawlsian theory or anything like that, versus sort of raw economic calculus, but to sort of the way constitutional moments are described in the Federalist Papers, right? And they have to do not with sort of personal calculus about riches. Will I, as a rich person, be better off with big deficits, or the other way around, right? The calculations have to do with sort of what will it take to fix this regime, this government, this country. Does that make any sense?
Well, no, what I really, I hear you, but what I'm really trying to say is, if we don't have a care for our children and their well-being, and I think there are many reasons why our concern for our children is much less than it used to be, broader cultural reasons. If we don't have that, what is it, why should any of us care? You're talking about for the well-being of our country, but I don't actually see how it plays out concretely until we're dead.
No, I get that, and if you're that despondent about it, and then we're in even more trouble than I thought, right? My point is that maybe if you can focus people on just on the question. I mean, look, you look around in politics.
Lunches. It's a free lunch.
Wait. You just follow ordinary politics, okay? And every once in a while, there is somebody from the CBO saying, I think the deficit will be 120 gazillion, quadrillion dollars, and then everybody goes back to bed, and the president says, I have an idea. A tax cut worth $2 trillion. How about it? Anybody in favor of that? Sure, let's go. Okay? I was hoping that, one of the things that constitutional amendment proposals can do, I think, is to, if they're to the extent that they're taken seriously, at least focus people's attention for a moment, right? And I think if you can focus people's attention as opposed to living in the moment, maybe they'll say, what's going to happen to us and to our kids 30, 40 years from now? That's a hope. Maybe all of that is gone from the culture. I'm not quite that despondent just yet.
I didn't think it was possible for anybody to be more pessimistic than Michael Greve. But Amy,
you've done it.
You have done it.
There.
Hi, Joel Samuels. A question also for Professor Greve, although I'd welcome views of anybody else. So I think you've identified the problem correctly, obviously. And I also actually agree with the need for a constitutional amendment, but I think you've picked the wrong one. I think a balanced budget amendment, which is a traditional conservative approach to that, is superior. But a couple of observations. Number one, is it wise to enshrine the Congressional Budget Office into the Constitution? Number two, doesn't that put a lot of pressure on dynamic versus static scoring of things like tax cuts, where the assumption is that $1 trillion tax cut costs the government $1 trillion rather than maybe generating more revenue. And number three, just politically, isn't this a free lunch for people who want to load up rich people with more taxes, because the consequence of overspending is going to be borne more by the people who pay more taxes, and we have a country where 45% of all people currently pay nothing in federal income tax, so doubling their proportion means nothing, whereas doubling the top marginal rate would mean 79.2% marginal tax rate, and wouldn't some people just love that?
Look, I'm with you, okay, except on one point. That's why I sort of cautioned that everything here is, I'm not wedded to any of the details. I was nervous about the CBO thing myself, and I mentioned that maybe you can tie this to something other than the income tax, although, the income tax rates as they now stand are not frozen in stone. Maybe it goes the way you describe. The outcome, I mean, in the sense of, hey, this may be an excuse for sort of people just soak the rich or whatever, right? Maybe it goes the other way and we finally rediscover that there's only so much money to be had from the really rich, and so you have to have a much more broad-based middle-class tax. That's what I meant, Jamal, by politically neutral. You don't know in advance how this shakes out, right? The one thing I am better to is I'm very skeptical, much more skeptical than you seem to be, about balanced budget amendments. The balanced budget amendments, spending limitations, right, that we have at the state level, they work by and large because we have bond markets, not because the amendments do anything on their own. Internationally, I mean, I'm familiar with some balanced budget amendments in European countries. Believe it or not, Italy had those in various versions. That has not worked very well. Even Germany's hasn't worked very well. And my goodness, I mean, if it doesn't work there, it can't work anywhere. The beauty of the Buchanan Amendment and a different version, which Sai will present tomorrow, I think, is you want to make people pay, right? So, I mean, if you want to sort of put this in the context of our recent political history, President Reagan's idea was you could starve the beast, right? You just cut the taxes and, people would look at the budget deficits and then, well, no, we finally have to cut back on things. Turns out, no, people have an infinite demand for deficit spending, right? And so the program has to be the opposite, which is make them pay. You can have anything you want so long as you pay for it. And you can then impose that cost either on the voters themselves, which is the Buchanan solution, or on the politician, right? And I'll let Sai talk to that. So that's the thinking behind that.
So I think
anything else is negotiable.
I think we have time for Sai and Sandy's question, but at that point we're done.
Actually, I've got two questions, one for Randy and one for Michael, so I'll be very quick. For Randy, Section 2 of his proposal talks about Congress having power to define and punish to provide and define for punishment of offenses against acts of war or violent insurrection. And the odd thing about that to me, Randy, is I don't know why that's in Section 2, because Section 2 purports to be about the necessary and proper clause as it relates to the Commerce Clause. And I wouldn't have thought that those two clauses together gave Congress the authority to regulate those things. And by putting it in there, you're actually implying that Congress otherwise would not have authority to do that if your amendment went into effect. And I don't think that's where the source of authority comes from for regulating those two things. And I don't think you do either, because you have a very narrow conception of the Commerce Clause now. So another way of putting the point is whatever power Congress has to prohibit acts of war, you don't believe comes from the Commerce Clause now. And so putting this in there suggests that you do think it is coming from the Commerce Clause and the necessary and proper clause. And then for Michael, his discussion of Article 3, it's only, that article I think has been amended once, but not very well. And I'm wondering if this this amendment is a little odd, because it seems to me it just says that the courts can't adjudicate cases involving rules, interpretations, et cetera. But wouldn't that just mean that the administrative law judges would decide these cases, and so it would just be more agency authority, not less?
Right.
And I'll leave it at that.
I'll take this under advisement, it was put in there just so that as a political matter, people would not be saying that if Congress doesn't have the power to reach, this is basically disabling Congress from reaching intrastate activity under these Supreme Court doctrines. And so this allows it to reach intrastate activities if they are for this purpose, rather than for the regulation of interstate commerce. It could be redundant of other powers, but this was to make clear that that could not be used as an objection to depriving Congress of the power to regulate wholly intrastate activity.
And as for the second part of the question, of course, I agree with where you're going with that question. The purpose of my amendment was at least to solve part of the problem of administrative power. And the amendment that I proposed didn't solve all of the problem. The other aspect of the problem is, cases in front of in-house administrative adjudicators. And I think that really gets to the civil liberties issue that's at the heart of the current approach that we have towards administrative power. So the aspect that I addressed in my amendment is, getting back to the enforcement of positive laws as opposed to the enforcement of rules which are not made by the lawmakers. Another aspect of the problem of administrative power as it currently exists is you have cases that are handled in front of administrative law judges, the vast bulk of which are not imposing legal or financial obligations, but some of them are. And I think I agree with your premise that that's the constitutional issues if you take separation of powers seriously as a protector of civil liberties.
Yeah, this continues an argument that Randy and I have been having for a while. Your current statement seems to be an important and lamentable step backward from the second edition of your book. Because, as you know, I think there is something to be said for your proposal. But in your book, as I recall, it was 2/3 of the states and a majority of the population.
A majority of the states with a majority of the population.
Which strikes me as far, far better than 3/5 of the states, given that half the population lives either in 10 or maybe 11 of the states. I'm just not sure. You could get up to 30 of the states, I suspect, with less than 40% of the total population. So it seems to me that your current statement is really an unfortunate step backward from majoritarianism. And I'm not sure why you have made that step backward, given that I think your proposal could actually get some allies from people who are not right-wingers, who do believe that there would be some value to review of congressional legislation, but not by giving that power, at least in theory and on occasion in practice, to 40% of the population.
Very simple answer. I did change the proposed repeal amendment in response to Sandy's objection to appeal to Sandy, and he put the new language in his amendments that he's going to talk about tomorrow. So the reason why it isn't in the proposals here is that I decided to confine myself first to the version that was introduced into Congress, which had the 2/3 requirement, and secondly, to the one that the state reps produced as a part of the Convention of the States. I actually, as advisor to the subcommittee that proposed that, urged them to adopt that approach, a majority of the states representing a majority of the population, for the reasons that you and I like. But unfortunately, I was a representative from Alaska, a woman representative from Alaska, that said, if that were to be adopted, you basically are just going to run roughshod over small states with low populations like us, and therefore, I've just no way that I'm going to ever support that. And as a result, it also occurred to me in the course of debating with her in the subcommittee, and that any amendment that's passed has got to get ratification from 3/4 of the states. And if all the smaller population states feel the way she feels, and I predict they would, you'd never get anything ratified with that provision. And for that reason, I reverted to the original. Influenced by the delegate, by the representative from Alaska, I reverted to the original proposal.
Thank you.
Yeah.